Welcome to episode 164 of our podcast series. I'm Stuart McCullough. I'm the CEO of VHIA, and with me today, or not with me, as the case may be, is the Manager of Workplace Relations Services, Tim Nagle. Welcome, Tim.
Thanks, Stuart. Good to be here, or there, or wherever I am.
It's good to be anywhere, I think, Tim, at this point. And this is a little bit of a different broadcast in the sense that we're not in the same room. And this is a special lockdown edition. But normally what we would do is that you would reach over and open the box and take out the clue and then try and guess the subject based on that clue. But we don't have a box as such. And what I'm going to do but we do have a clue, which is this. So this is a block of Cadbury marble, and I'm just going to pass this over to you.
Yeah.
So the interesting thing about this particular flavour, Tim, is that in 2017 it was discontinued. And the company at the time said that they were going to really branch out into other flavours. And having regard for today's subject, presumably that other flavour was failure. But Cadbury Marble has been brought back into the market, and the subject for today really is connected to the reintroduction of that product because success has followed the return of marble to supermarket shelves. But based on that particular clue, what would you say that the subject for today's discussion is?
So it's going to be, it's pretty obvious that it's Cadbury chocolate, which you eat. So clearly the topic today will be meal breaks.
Tim, you couldn't be more wrong. So whilst that's a very good and brave guess, the subject for today does pertain to the chocolate, which is the parent company is a company by the name of Mondelez. And we're going to be talking today about a High Court decision which has settled a question with regards to the meaning of a day for the purposes of personal carers leave under the National Employment Standards.
So on the 13th of August 2020, the High Court of Australia handed down its decision in Mondelez Australia Pty versus Automotive, Foods, Metals, Engineering, Printing and Kindred Industries Union, known as the Australian Manufacturing Working Union, and that case references on the screen now. Tell us about that decision.
So the first thing is it's been a long time coming, and I know that people have been waiting for that decision. It's provided a lot of clarity, and as I mentioned before, the case goes to the issue of the National Employment Standards, in particular to personal carers leave, and the meaning of a day. The NES prescribes 10 days per year of personal carers leave as the minimum entitlement. And really what the case turns on is how do you apply that entitlement for somebody who works longer than a standard day, that is longer than 7.6 hours?
So we probably should start with some context. As we know, the High Court is the highest court in the Australian judicial system. How did this case come before the High Court?
So the High Court is really functioning there as a last stop of an appeal process, and it follows a majority decision of the full court of the Federal Court of Australia concerning how that entitlement was to be calculated under the NES.
So it really pertains to Section 96(1) of the Fair Work Act, and what does this provide?
So Section 96(1) concerns personal leave, part of the National Employment Standards. That means it forms part of the minimum terms and conditions for all employees. And what that says is that for each year of service, an employee will be entitled to 10 days of paid personal carers leave. So that's the minimum entitlement.
But that all seems pretty straightforward. How did we get to the High Court?
It does seem pretty straightforward, but there's a statement in the Federal Court decision which says that for a provision that is expressed so simply, it is surprisingly complex, and that's really been borne out in the court process.
So how did that provision cause so much disputation?
So it all concerns the meaning of the term day, and in the context of 10 days of personal carers leave. So the court contemplated whether a day refers to a notional standard day of 7.6 hours or the actual day of the individual employee who may work a longer day than 7.6 hours.
So Mondelez argued that the day in Section 96(1) does not refer to a calendar day nor working day, but rather is industrial meaning of a notional day. Can you elaborate on what a notional day is?
Yeah, look, it's really interesting. So a notional day is really that idea of a standard day. That if a week is a 38-hour week, and the assumption is that there are 5 days for a full-timer that are worked in that 38-hour week, you're talking about a 7.6 hour day. And that's not just something that they pulled out of thin air. That's something that really came from the explanatory memorandum, which we'll come to in a moment.
So so in terms of the explanatory memorandum for the Fair Work Act, it did address this issue, did it?
And that's the interesting thing. So the explanatory memorandum was incredibly clear in the sense that it talked about that if a person works their 38 hours through a non-standard length of day, it doesn't affect how much personal leave they accrue in terms of the number of hours. So 10 days, 2 working weeks, 76 hours per year of personal carers leave. If you work your 76-hour fortnight over 8 days, for example, rather than over 10, it doesn't increase the number of hours that you accrue as personal carers leave, according to the explanatory memorandum.
So on this basis, what would a hypothetical employee receive if they work 38 hours a week?
So a person who works 38 hours a week will, under the NES, will accrue 76 hours of personal carers leave per year, no matter how it is that they work those hours. No matter how you cut it, whether it's 5 days of 7.6 hours, whether it's over 4 days or 3 days, whatever it is, it will still be 76 hours for a full-time employee.
And what if that employee was sick? What would happen?
So just in terms of, there's a really important point here. So if somebody is sick, then they will be paid for the shift that they missed from that accrual. So if somebody misses a 7.6-hour shift, they'll be paid 7.6 hours. If they miss a 10-hour shift, they'll be paid 10 hours. There's a distinction between the rate of accrual and payment for a day of absence.
So in this case, the union argued that a day should be interpreted as a working day. What is a working day in this context?
Yeah, so in this context, a working day refers to the portion of hours in a 24-hour period that a person is at work. So, in a practical sense, if a person works 10-hour shifts, a working day would be 10 hours.
And so how does this apply to a hypothetical employee who works 4 shifts a week of 10 hours?
There's been a lot of talk about a hypothetical employee, and frankly, just between you and me, they're clearly a troublemaker. But leaving that to one side, on this construction, an employee who worked, say, 10-hour shifts would be entitled to 100 hours of personal leave per year instead of 76, notwithstanding that overall they're still working 38 hours a week. So that would be on the basis that a day is 10 hours, 10 times 10 being 100.
So under the union construction, an employee who works 10-hour shifts will be entitled to more personal leave than an employee who works 8-hour shifts.
That's correct. So you've got people who are both full-time, both working 38 hours, but getting a different outcome in terms of the number of hours of personal carers leave under that construction, which, bearing in mind the majority of a full court of the federal court said was correct.
So after considering the two meanings, what did the majority of the full federal court decide?
So the full federal court did adopt that union construction, and which did mean that there could be a differential. And they did that really by diving into this notion that it's almost like an insurance as such for being ill. There was a minority opinion or decision in that case, which was much shorter, much succinct, and relied on that explanatory memoranda and said that the Act is such that you can rely on these other materials, such as the explanatory memoranda. The memoranda is clear, therefore it should be on a notional day, and disagreed with the majority of the federal court.
But the majority decision was that they found a day to mean a working day.
Correct, and it's really interesting. It's sort of then you get a lack of uniformity as a result of that kind of outcome. And it means all sorts of really challenging things for how do you do that from a payroll perspective. as such. I don't know that there are any payroll officers who were necessarily called as witnesses in that case.
So what did that mean for the employees of Mondelez more broadly?
So from memory, that the people in Mondelez were working 12-hour shifts. And I think it was a 36-hour week that was full-time. It meant that they were entitled to 120 hours of paid personal leave per year under the NES. And it meant that I think from memory, that the NES entitlement was therefore more beneficial for them.
So that decision was appealed to the High Court. How did the High Court view the working day construction?
Well, to put it directly, they rejected the decision, the construction placed on it by the majority of the full federal court. It supported the idea that day in this context refers to a notional day.
So how does that work?
So the way that it works is that it's a standard day of 7.6 hours. So if the entitlement is for 10 days, and the explanatory memorandum makes clear that 10 days equates to 76 hours, then it means that no matter what your shift length is, you get to 76 as a full-time employee per year under the National Employment Standards. What was really interesting about the High Court's decision was the focus on the requirement under the Fair Work Act for fairness. And the way that they expressed it is that taking the working day approach would result in people getting different amounts of personal leave, even though they were both full-time employees. And they noted that that was inequitable in terms of an outcome.
So in terms of its conclusions, what else was considered in the High Court decision?
So they took an approach of, the standard approach to statutory interpretation, and through that, and having regard for the explanatory memorandum, got to that point that 10 days is 76 hours per year, and that all people who work full-time get the same amount of personal carers leave under the NES, no matter how they work that time.
So what's the result of this?
Well, it's really interesting that you should say that. So really, the result of this decision is to confirm the long-held understanding of the status quo. The Mondelez decision was challenging for employers in that it threatened to upset that status quo, threatened to upset what had been long understood about how to correctly calculate and apply personal carers leave under the NES, and in some cases, enterprise agreements. And the idea that you would have people who were the same proportion to full-time or getting different amounts as a result would be an extraordinarily challenging thing, both in terms of equity, but just in terms of administration. How do you administer an entitlement like that was a real question.
So how did the High Court account for the fact that patterns of work or distribution of hours do not always follow 2-week cycles?
Yeah, so look, interestingly, the High Court also stated that the personal leave entitlement for the NES can also be calculated as 1/26th of the employee's ordinary hours of work in a year.
So the decision clarifies the entitlement to 10 days of personal carers leave under the National Employment Standards. But does this decision have any impact on the way in which personal leave accrues and is paid in the various health sector enterprise agreements?
Yeah, look, that's an interesting one. Predominantly, our agreements talk about personal leave in the context of hours and minutes rather than days. The exception is that would be for doctors. The most immediate challenge that it had for us was in the context of bargaining. Would we receive claims to fundamentally change the way personal leave was calculated? And we did receive some claims in that respect, but as a result of this decision, the status quo has been preserved.
And there's a little bit of a safety catch in the agreements, isn't there? So they often say that if the National Employment Standards provide a more favourable outcome, then that applies.
Indeed, and we had that discussion in the context of nurses, where we had to weigh up, there was a request to change it, to align it with the more favourable of whether it was the NES, and we managed to navigate our way through that, but this decision means that really that nothing will change.
With the High Court decision, will there be any issues of National Employment Standards compliance within our agreements?
No. So that's what we've avoided. We were in a circumstance where if the majority decision of the federal court had prevailed, then it would have been a circumstance where for people at the start, particularly of their employment, if they were working a certain length of shift, it was possible that the NES was more favourable than our agreements, meaning there was potentially two sources of entitlement that had to be taken into consideration to get to the right answer, which of course would have been complex and costly. But because the High Court has decided that the way it has, we don't have to worry about that and we can continue on as we were.
So what does this High Court decision mean for employers?
Really simply that the status quo has been preserved. It's as simple as that. So the understanding that people had as to how it worked has been upheld, and it means that there isn't a change, which I know will be welcomed by employers.
On the face of it, it seems quite simple, but obviously it was much more complex than that. Why was the question so difficult to resolve?
One of the interesting things went to whether or not there were grounds to look at materials other than the Act itself, and in particular whether or not you could use other materials as an aid to construction. And part of there seemed to be a tendency for some to say the Act is perfectly clear, don't need to look at the explanatory memorandum. And that approach tended to favour the idea that day was whatever day the person worked. For those who said that, well, clearly it's unclear, you are able to utilise these materials which are intended to explain the Act. That's the purpose of an explanatory memorandum. You are able to use those materials as an aid to construction, and on that basis, it's clear. But what was interesting about the High Court, it went further than that. It wasn't just simply a matter of saying, use the explanatory memorandum, it's very clear, that's the answer. That they actually reached further to identify notions of fairness and indeed unfairness with that idea of the actual day and fairness in the context of the notional day.
That's why it's so odd a little bit that, as you touched upon, the explanatory memorandum was very clear about how it should be interpreted.
It addressed the issue head on.
So where can people read more about this issue?
Well, for those people who have obviously reading the High Court decision is incredibly informative and as such, but if people wanted to go back in time, they might want to familiarise themselves with a decision from our sector from about 6 years ago, which was an application made by VHIA and Monash Health. It's a decision of a single commissioner, but effectively the decision is consistent with Mondelez. It was Mondelez before there was a Mondelez.
And I understand the key witness in that case was from memory one T. Nagle.
And it's correct, a difficult witness though, it has to be said. And from memory, there were certain attempts to cast doubt upon his evidence that was given. I think he was described as being unreliable, untrustworthy, and those were just the points that I made.
For those who might be curious to read a decision that was Mondelez before Mondelez, the decision we're talking about then is Monash Health 2014 at the Fair Work Commission of Australia 1924.
Tim, thank you so much for taking the time to discuss Mondelez before there was, discuss the High Court decision in Mondelez.
My pleasure. Thank you.
Thanks, Tim. VHIA.com.